Hello and welcome to episode 6 of season 2 of Lawfully Yours. We are your hosts. I'm Vickki Ridgway. I'm a chartered legal executive and director of ESAT and Ridgway. I'm a litigation specialist. And who are you, my dear?
Today, I am Geraldine Watson, family law solicitor, director of A&C Law Limited, and consultant solicitor for Parity Legal and AGR Law.
Wow.
Family law solicitor.
Family
I don't know if I said that bit.
Well, I think it goes with the title.
Geraldine Watson, family law solicitor. Yeah,
I
suppose so.
So it seems, for our listeners, obviously they only heard us 2 weeks ago. But for us, it's been about 6-7 weeks, hasn't it, since we actually recorded.
Yes.
So we've had quite a lot to catch up on, really, haven't we? And some of it we'll go through today. Some of it's probably not listener.
Yeah, not listener friendly.
No. So how have you been?
I've been all right.
Yeah?
I've been really good. Yeah.
You've been busy?
Yes.
Yeah.
As always.
Yeah, I've had quite a busy. So we're recording this sort of December. Quite a busy start to the month, really. December's always busy because you've got to catch up with everybody and you've got things to do and stuff. So in November, my friend and I, we always go to London.
I saw that,
And we do like a Christmas craft show or something, and then we do a show. And we saw Paddington, and oh my God, if you get the chance, anybody listening, if you get the chance, it is incredible.
Really?
Honestly.
At the theatre or the cinema?
At the theatre. At the theatre at Savoy. It honestly, I cannot tell you. Both my friend and I had tears.
Really?
It was wonderful, absolutely wonderful. And we had a really good day in London, a really good weekend in London. It was fab.
Oh, that was nice.
Absolutely fab.
Nice to have a break, isn't it, sometimes?
Yeah.
We've just been to York.
Okay.
Went there Sunday
York.
till Tuesday yesterday.
Did you go to the races?
No, we didn't do the races.
No.
It's a bit cold for the races, I think. I like to go wear my hat and a nice dress and stuff like that.
Was the Christmas market on?
Christmas market.
Love it.
Oh, they're probably one of the best. I love a Christmas market.
Yeah.
They're probably one of the best.
Yeah.
Really, really nice.
Yeah, I do love York and what is it? Is it the Rambles?
Shambles. Yeah, went down the Shambles.
Yeah.
Piece of advice: if you go to the Shambles to go to the shop, massive queue. But when we were there, so not this time, the ghost shop.
Oh right, okay.
For the Shambles and the ghost shop to buy the little ghosts.
Okay.
Yeah.
I've never done that.
Oh, okay. Apparently I didn't know about it, but my I didn't know about it, but my daughter, she told me about it.
Okay.
And she's like, you can go to the ghost shop on the Shambles,
and
they're like little miniature ghosts or big ghosts, and they're obviously all authentic and stuff like that. The shop is tiny, and you have to queue outside in the middle of the street, and then there's someone letting a few people in at a time, probably 5 or 6 people in at a time. But when we were queuing, we got told about another ghost shop,
right,
which is probably a 20-minute walk away, no queue. So we thought, okay, well, not this time. So last time we went to the other shop,
right,
there was a bit of a queue, but it was better.
And did you buy a ghost?
So yeah,
how big is your
more
ghost?
than one. It's actually, I should have bought it. It's only like that actually.
And how much was said ghost?
20-30 quid.
No.
Yeah.
And what are you going to do with it?
It's in my office. It's really cute actually. It's really, really, really cute.
Okay.
And I bought my daughter one, my stepdaughter one. They're really nice. They are.
Okay.
They're really nice. And the shop is so nice. But this time it was for the Christmas market and the Christmas lights.
I do. I'm actually going to Bath Christmas Market this week. So I do love a Christmas market.
It is really nice.
Just gets you in the mood, doesn't it? I love mulled wine, walking
around. No, I don't like mulled wine.
Love it.
No.
Love it, love it, love it.
Went to York Dungeons.
Oh.
Would not recommend it.
Oh, okay.
No. I thought it'd be like the London Dungeons.
I've never been there either. I
you've
can't think
not?
of anything worse, no.
Why?
It's the dungeon.
Really good. Really good. The London one, but the York one, wouldn't recommend it.
It's not like a Christian Grey dungeon.
No, okay. Do that one.
Just putting it out
but
there.
not the other
Just putting
one.
it out there. So, as you can see, I've had my hair.
I know, it looks lovely.
So I had a bit of I won't say a wobble, but I had, that would probably be about 7-8 weeks ago. I knew it was going to happen because it's hereditary, but I've got bilateral hearing loss and I had to have hearing aids, and I just felt old really quickly, and I thought I've got to do something about this, because if I don't, I'm just going to go down. So I had new glasses and I had my hair done and it worked and I feel okay. And I have to say that I didn't realise how hard of hearing I was. You know, when you don't wear glasses, but when you get new glasses and you put them on, you think, oh, crikey. You know, I didn't realise I couldn't see as well. And now when I take my hearing aids out, everything's like really dull. But that's been normal for me for so long.
Yeah,
and
I know
you can't
your pain.
tell. I mean, you can't.
No, when you told me about them, I was amazed.
Yeah.
I was amazed.
Yeah,
But you've encouraged me to go and get.
Yes, because apparently you are.
I'm not very good.
hard
And everyone
of
in the
hearing.
house moans how loud the TV is. And I have to admit, professionally, it's not great sometimes when I'm in court. I'm trying to hear the judge. And I have to ask the judge to repeat themselves sometimes. So
You don't ask them the way that you asked me outside. You're like,
what? No, I do have a court voice.
So you on the hearing aids that I've got, you have an app on your phone and you can do settings. So you could have a court setting and literally you can just zoom in on the
It
judge's
does sound
voice.
really good, but you did pay a lot for your hearing aids and the app. So
I did.
I'll see. The first thing is to go for the test, isn't it?
You get, it's 100 day. So I went to Specsavers, as everybody does. You get 100-day money back guarantee. So if you have them for 100 days and you think, no, it's not making enough of a difference, then you can send them back, get your money back. But I have to say, they're not going back. So.
And you said as well, there's a setting that it can block something out or something.
Yeah, so if you're in a restaurant, that's where I found, and networking, that sort of thing. When you're having a one-on-one conversation, there's background noise. I found it really, really difficult. And I was just sort of, yeah. But you can set it so it cuts out the background noise. It doesn't make it like that it's not there, but it dulls it down, and then you do like a speech clarity, so that when I'm speaking one-on-one with somebody, you can literally, it's absolutely brilliant. Honestly, I would go so far as to say it's life-changing.
You get like some companies do it. If you recommend someone, you'll get like £50 or something.
I don't know, actually.
If you do, have a look,
I'll
and then
have a
you
look.
can recommend me, and then you'll get maybe
I
something.
will have a look.
But yeah, that's definitely something for me to look at.
Yeah, definitely. How's work anyway? Has work been busy, productive?
I don't know with you, but in family law, it goes in peaks and troughs. So sometimes it's really busy and you don't have time to do anything. And then sometimes you get a chance to catch up, and then you say those words, oh, great, I can catch up this week.
Don't ever say it. Don't ever say it.
And then all of a sudden, it just goes
Yeah.
crazy again.
Yeah.
And so I got a new inquiry, I think it was a couple of weeks ago. I think it was about the Tuesday or the Wednesday, and she had a hearing on the Monday. And I was like, okay, that's fine. Send me all the stuff. So she sent me all the documents and everything. I spent the weekend working, going through everything. We had the hearing on Monday, and it's finished.
Oh, wow.
Case finished. Literally,
Wow.
just like that. Obviously, I hadn't been involved before,
Yes,
like when she
yes,
made the
yeah.
application.
Yeah.
So as sometimes people do, they come to you at the 11th hour.
Yeah.
And they say, oh, I've got a hearing on so-and-so, can you help me? And you prioritising, you depend on the case, and if you feel that you can.
Yeah.
Because there's no point, nothing worse than saying to a client, oh, yeah, I can help you, and then you can't.
Yeah.
But yeah, it was fine. It all got settled,
Brilliant.
done and dusted.
And what was the hearing?
It was to do with children.
Okay.
Children at proceedings. Just trying to think how to say it.
Had she? Yeah, don't worry. I know.
Yeah.
Obviously, without giving too much away, had she'd been representing herself? Had
Yes.
She? Okay.
Yeah. Yeah. And then I
Well,
think
well
when it
done
came
you.
to this, she just felt a bit overwhelmed by everything. The other side had always had representation. Sometimes they feel a bit bullied.
So it was a bit of an uneven playing field, really.
Yeah, and the hearing was really important.
Yeah.
And we were supposed to have been there a couple of hours. We were there literally all day. Finished, I think it was
Gosh.
about 3:45.
Wow.
But the day was well spent because,
Yeah.
I say, we got a final order and it's done.
It's done and
Done
dusted.
and dusted.
Brilliant.
Yeah. Yeah.
Brilliant.
What about you? Busy?
Yeah, really busy actually. I've had so when you're dealing with serious injuries, the cases can last 3, 4, 5 years, sometimes more. And I've had a flurry of the longer running cases of late that have settled. So I settled another one yesterday. A chap involved in a head-on collision sustained serious life-changing injuries. He's had a lot of appointments with medical experts and everything, and the future for him is good, but he's going to have problems as a result of his injuries, physical injuries. And we settled his case, and it was like, I don't know, it's you sort of, you go through the motions of running the case because there's a procedure to follow, and you've got to get this report, that report, another report. You've got to gather all the evidence, and you sort of just go along with the process. And then when it comes to the conclusion, not that it comes as a surprise, but it's like whoa. So all that 3-4 years has accumulated into this one conversation, and that's it.
Wow.
You know. So, and for this guy, he had his children in the car with him at the time,
Oh, dear.
and they were also injured, but not as badly. But we've settled the daughter's claim as well, and the son's claim.
So were they separate claims then?
Yeah, because they're separate individuals having their own unique injuries.
Yeah.
And it's just for a family to be able to conclude that, particularly just before Christmas. I don't know. It just warmed my heart really, and it was. I think sometimes you feel a little bit of a loss because it's like I speak to this client on a regular basis. You know, he messages me, and it's like, and he was really grateful when I spoke to him on the phone. He was just so pleased is the wrong word, because I say he's got life-changing injuries.
I imagine it's quite overwhelming going through that whole process, and then that part of their life is not finished, but in respect to the legal aspect of it.
So I think it's important to recognise that when you're dealing with someone who's been injured, whether it's personal injury or clinical negligence, for them it's about getting answers and getting justice. But whilst that claim is ongoing, even though they are suffering with their injuries, the fact that the claim is ongoing, it's a constant reminder of what happened. Yeah. And whilst now the claim is settled, obviously it's still going to have the ongoing problems, but it's almost like a closure for them. And I think they probably, to a degree, feel somewhat of a loss as well, a bit of a bereavement, if you like, because they've not then got that focus. But they then have to find another focus in terms of, right, that part of my life we've done. Let's see what we can do, you know. And the compensation, again, is going to change his life. It's going to make things a lot easier for him. And it's going to help him in the future deal with what he's got to deal with, because he's going to have further surgery, going to need further time off work. Wow. But the compensation will cover him for that. So it's a really.
Did it take so long because they didn't admit liability then?
No, liability was admitted fairly early on. There was an argument, but it was admitted fairly early on. But because of the extent of his injuries, we needed several medical reports, and we needed MRI scans, and then he had surgery, so we had to have another report after the surgery. And so it's the process that you follow in terms of, right, well, that's the physical side of that part of the injuries. Then he got other injuries that needed a different expert opinion. Wow. So you've got someone dealing with facial injuries, leg injuries, psychological, all sorts of things. So, and then each report, if there's recommendation for treatment or further investigations, you have to obviously follow that through. The idea is to get a full picture of what impact those injuries will have on that individual, both now and in the future. And then obviously you can calculate as much as you can as to what those future impacts might have on his financial position, whether he's going to need care, whether he's going to need adaptations to his home, that sort of thing.
Right. Yeah.
So, yeah.
Wow.
Yeah. So it was quite humbling, I think, that how grateful he was. And, you know, his words were, we can have an amazing Christmas now. Aww. And I don't think that's because of the money, because he probably won't get the money before Christmas. Yeah. I think it's because it's that underlining.
It's settled. It's done. I'm not going to get involved anymore. Yeah.
Absolutely.
Oh, yeah. That's good.
So yeah,
yeah. Shall we do? So we're doing this episode slightly different, aren't we?
That's right. That's what we were going to say, wasn't it?
Yeah.
So it's just us today.
Just us today.
Because we thought it would be interesting both for us and for our listeners to know a little bit more about what we do,
and how we can help people. And we sort of looked at the most common questions that people ask us, probably at the outset, really, and it's quite difficult to answer those questions at the outset because you don't know how it's going to progress. I think it's also to help people get a better understanding of your area law,
Yeah.
my area,
Yeah.
because to us it's obvious.
It is, and I think we've spoken before about how family law and litigation cross over in quite a few ways. We had an episode on Talata, didn't we, where there's property owned jointly by individuals who are not married.
Yeah.
And we also sort of had a discussion recently about quite a unique point of law, wasn't it, about properties owned by married or unmarried couples in a foreign jurisdiction.
Yeah.
And the uniqueness of those cases, and how there's an overlap. So you were dealing with a property for a family who were getting, or a couple
Getting
who were
divorced.
and I was dealing with a property for someone whose husband had passed away, and she wanted to sell the property. And there's all the intricacies of the different jurisdiction in terms of what you need to do.
Yeah.
Very simple for us in the UK in terms of how you would sell that property. Very different in a foreign jurisdiction.
Very different. And the things that you have to do to be able to even get to the stage where you can think about selling the property, and other experts that you have to get involved in that jurisdiction.
Yeah.
So I think because there is a lot of talk to talk about that, we're going to do a different episode about that, aren't we?
We're going to do a focused episode on the differences and the things that you need to look at.
And the difficulties that happens.
And I think probably that's something that people perhaps ought to think about before they buy those properties.
Yes, definitely.
And I think that's something we've spoken about before, both in the UK, properties in the UK as well. You know, people are in love and they want to buy a property and, you know, an investment or whatever, and they don't necessarily think about what may go wrong. And that can be married couples, that can be family members, or, you know, friends buying together. So I think, that's a whole other episode. Yeah,
so
and we're going to be recording that fairly soon, aren't we?
Yeah, we are. Yeah.
Aren't we? So should we do a jezza before we get into the heavy stuff?
Okay, so this was quite funny actually. So I think it's funny anyway. So where I live, you have to go over a couple of small mini roundabouts, and
over or around.
Well, around then, not
Okay.
over. You don't drive over the roundabout unless you're drunk, maybe. Anyway, so going around this roundabout, it's a pretty new estate, so they're still developing it, and they've got some like nice decorative areas and things like that. Anyway, so I was driving I was driving along the road, heading to one of those mini roundabouts, and I saw on the side what I thought was a dead body wrapped in a sack. You know, like those beige sacks with a rope tied around it. It looked to me like a dead body. I freaked out. I was like, oh my God, what am I going to do? But as I got closer, I realised it was just a big rock. That's it.
You know, when you go to Specsavers to have your ears tested, maybe you should get you don't wear glasses, do you?
When I'm driving at night time.
Maybe you need to use them when you're driving.
Honestly, I freaked out.
I bet you did.
It looked like a dead body.
What would you have done?
I would have called the police. Well, I would have gone over maybe and had a little look, had a little nosy, and then called the police.
Oh my God.
But it was just a rock, just a big boulder.
You've just reminded me about dead bodies.
Okay,
just one thing I wanted to... We normally talk about what we've been watching on TV. So we've just watched the latest 24 Hours in Police Custody. And it reminded me of you because it involved a family dispute.
Okay.
And it was really quite harrowing. It happened in Cambridge. And there was a custody battle. A couple had a custody battle over a child that they had together. Mum had married someone else who was American, had a child with him, and they wanted to emigrate to America. And dad of this boy said no and basically fought through the courts, and he was awarded custody. And I believe it was on the same evening that the decision was made that the mum's dad basically got a shotgun and shot the dad of the boy and the granddad of the boy, so the other granddad, basically blasted them. And it just made me think that how emotional these situations are. And they never sort of explained, or the killer never explained why he did what he did. But the only thing that sort of came to my mind was that if he got rid of the people that were in the way of his daughter emigrating, then she could live her life.
Yeah.
But my God, what an extreme. I mean, that doesn't happen very often. That is an extreme example.
That's never happened. You do get extremes.
Emotions are real run high, don't they?
Yeah, very high.
I think, again, both in family and litigation, because it's all about conflict, isn't it?
Yeah. You do get sometimes you get emotional responses that really aren't warranted just to try and protect their position.
Yeah.
Awful.
Yeah, it is awful. I don't want to give him any airtime because it was just a cold, horrible. Anyway.
Yeah.
So
we're going to do it differently, aren't we?
We are.
The questions.
We've got a list of questions that we get asked quite a lot. Can you reach? That we get asked quite a lot, both from a litigation point of view and a family law point of view.
Yes.
And we thought, well, if we're getting inquiries from people that are asking these questions, then there must be people out there who are also asking these questions, and either think that, you know, they've got to pick up the phone and pay for that advice, you know, and probably people that are thinking, I'm in this situation, what can I do about it? How much is it going to cost me? What's the process?
I think for me as well, the thing is, because we know what we do, we assume people know what family law is,
what a family lawyer does, what a litigator does. Yeah.
So I'll often get asked, do you deal with this? I'm like, in my mind, it's like, well, yeah.
It's obvious.
Of course I do.
Yeah.
So I think the first question is a good question.
Yeah. Okay. So do you want to go first or do you want me to go first?
So what is litigation law?
Good question.
I know.
So litigation dispute resolution is effectively when you have two parties that can't agree on something that they disagree on, basically. And litigation is the process to try and narrow down those issues. He says, she says, or he says, whatever. And it's the process of reaching a resolution through the court system. Okay. It doesn't always have to go to court, but the process is identifying the issues, seeing where there is a compromise, or perhaps, you know, there could be a compromise, whether there is a right or a wrong, or whether it's a 6 of one, half dozen of the other, and how to try and reach an agreement, and to record that agreement, to make sure that it is firm, it's clear, concise. And if you can't do that without getting the courts involved, then you follow the court procedure under the civil procedure rules, and you then prepare the case, bring it before the court, and the judge makes the decision on the basis of the evidence that's given to him.
So literally it could be any dispute.
Absolutely anything, really. So the most common ones that we have are neighbour disputes, so boundary disputes, can be they've put an erection up. They've erected a building or something that overhangs on somebody's property, or there's a dispute about what was one I had recently. So I've got an ongoing case about a retained wall, I think I've spoken about before. Somebody replaced a fence but put it too far over to my client's side. It can be a dispute in terms of the terms of a contract. So one person says, well, this should be interpreted in this way, this should be interpreted in this way, and we're saying no, or vice versa. It can be unmarried people, so family members had disputes over property, lease disputes. It literally anything where there are two people or two groups of people who have conflicting views. Generally speaking, a litigator will be able to help.
Is there anything you can't deal with?
Probably, but there's not really. I can't sort of say it's not. We don't do that. We don't do that. I think
depends on the circumstances.
Yeah, you have to look at. And sometimes it might be that you need a litigator and a property lawyer,
right?
Or like we've talked previously about property disputes for unmarried couples or whatever. You know, you will do so much in terms of a point, and then it would go over to a litigator. Because of the process. And I think the family law rules and the civil procedure rules are very different, aren't they? And I think some family lawyers don't like to, and that's absolutely fair and fine. We do employment law, so we dispute with an employer. or an employer having an issue with an employee, we can deal with that.
Okay.
So it's very wide, and I think if you have any question as to whether that is something that a litigator can do or not, ask a litigator. And most litigators will be able to tell you on the first telephone call whether that is something they can help with or not. And if they can't help, then who is best to help them, whether it be family, property, probate.
Yeah.
We do a lot of wills and probate disputes.
Oh, really?
So again, dad's left one of the children out of the will, and that person wants to contest. We have a lot of cases where you've got people that are living together but not married, and the person who's died hasn't left provision for the person that survived and continues to live in the property. And then you've got son or daughter wants the property because it's dad's, and the person that's living in the property saying, well, no, I need reasonable financial provision. So lots and lots of things that a litigator does that perhaps you wouldn't necessarily think is litigation.
Because I would have thought that the wills would have been fall under the probate category.
No, so if it's disputed, so obviously if you've got a will or you want a will making, that's not what we do. Yeah. But if you want to dispute whether a will is valid or whether it was signed properly or anything like that, then that's something that a litigator can get involved with.
Oh, okay.
Yeah.
Okay. So what are the advantages and disadvantages of litigation law?
Well, let's deal with the advantages first. So the advantages are that you get certainty, you get a concise agreement that's recorded, whether it goes to court or not. So if it doesn't go to court, you sign a settlement agreement and release to say, this is the dispute, these are the terms that we've agreed. And then essentially, if either party breaches that agreement, then the next step is to take it to court effectively. So you get the certainty. You get something that you can act on if either party doesn't follow what the agreement says. It's enforceable. So if you get, for example, if somebody owes you money and you get a judgment to say they owe you that money, they agree to pay it. But if they don't pay it, then the next step is to enforce that order. And again, if you just got, oh, he says he'll pay, that's okay, then that's not, you're not getting that certainty, that outcome. It's legally binding. There's a procedure to follow, so both parties have to follow the same procedure. And that's so that it's an open card, it's an open table approach, so you know what the other side's evidence is, whether it supports them or not, and vice versa. And I think it's just having that resolution, that final resolution. Disadvantages, time, cost and emotion, I think. Some cases can take years and years and years, depending on how strong people feel, what the issues are, what evidence is needed. That means that it can cost a lot of money, and it's about having some perspective in terms of, is it worth me spending X amount of money to get that resolution? Is that resolution really important to me? Because I think principles are a big thing. We've spoken about that before. It costs money. Yeah. And the emotion of it. When you've got a mother suing a son, or brothers suing each other, or, it fractures families. And sometimes there's no coming back from that, and the emotion of that, the having to deal with the dispute and then having to deal with the fact that you're never going to speak to this family member again, or that there's always going to be that bad feeling. Don't get me wrong, sometimes, particularly with mediation, you sit down, you have that discussion, you reach that agreement, and families are able to move on from that. But yeah, it's the breakdown of relationships is a massive thing too. And obviously by the time they get to the point where they're looking to instruct you, that relationship is already broken down. And sometimes people don't want to give in despite the cost, and that emotional cost and financial cost.
Okay. I think you've answered this bit. Do all civil cases go to trial?
No, and that's always the issuing of court proceedings is always or should always be the last resort. You should always, and as a litigator, the first conversation you have with your client is, look, this is where we're at. This is the dispute. These are the possible outcomes. These are the likely costs or the probable costs. And this is what we need to do before we get to the point of saying, right, the only step we've got is to issue court proceedings. Even if you issue court proceedings, that doesn't mean that it has to then go to a trial, to a final hearing. There are always opportunities to discuss a possible settlement, compromise, mediation. But what I think clients or potential clients need to be aware of is that as soon as you take that step of instructing a lawyer, you have to be prepared that that might be the eventual outcome. So no, not all cases go to trial, but a litigator's role is to prepare that case for a trial from day one.
What would you say the percentages of cases going to trial?
I would say of the cases that we deal with, I would say probably only 10% go to court. Probably less than that.
That's probably a reflection on you and how you manage to settle it as well.
And probably the clients as well for listening to the advice. 'Cause at the end of the day, they're instructing you, they're engaging you for your professional services, your knowledge, your experience. And at the end of the day, if they're not going to listen to that advice, then that's on them really. We can only give them best advice. Yeah. And I think the majority of the clients will say, yeah, I get where you're coming from. I just want this at an end. I just want, and it will settle. Yeah. So it's a small proportion, I would say.
I would say, how long does civil litigation take? But I suppose that's how long is a piece of string, isn't it, really?
Absolutely. Yeah. You can have two identical cases. One you can settle within 6 months. The other could take years. And it really does depend on the personality of the individuals involved, what the aim is, I guess the value, the likely outcome, what the impact that it's going to have on them if they win or lose, how important it is to them. And I think attitude, like we say, principles will delay, principles will cost, and sometimes it's choose your battles.
I think it also goes back to that case example you gave earlier about the one that you just settled. Yeah. So there wasn't really a dispute, but the reason it took so long was because you was having to get all of the evidence.
Yeah. So if you got for the children, because their injuries were much less serious, we were able to settle those much quicker. Yeah. Albeit there are other procedural points that we need to deal with for children because they're not able to accept the offer themselves. Yeah. We have to get the court to approve that. Yeah. But you can have two people involved in a road traffic accident. One, in the same road traffic accident, one will have potentially serious injuries, psychological, and the other will have a whiplash injury. And it really just, you can't say your case will take 6 months. We can give averages, but if this happens, then it's going to take longer. And as you know, the court backlog is just incredible. Yeah. And we have no control over that. The court has no control over that. And so obviously, as talking about earlier in terms of advantage and disadvantage, the time in terms of getting that case to a final hearing is massive because you've got to get all of the evidence before you can even say, right, we're ready to issue proceedings or whatever. So, the answer to that is how long is a piece of string, really?
What is the burden of proof in civil cases?
Right. So in criminal proceedings, as I'm sure people who watch dramas and things know, it's beyond reasonable doubt because the implications for someone who is accused of a criminal offence is obviously loss of liberty. They may be imprisoned, etc. In civil cases, the burden is much lower. You only have to show that it's more likely than not, so on the balance of probabilities. So if you can show that there's a 51% chance or more that what you are saying is true, then effectively you're home and dry. And it's 51% is so a 49% chance that you're not going to succeed. And I think that's a real. So for the burden, it's clear in terms of, well, I've established that it's more likely than not that the defendant collided with my client or whatever. But when you say to a client, oh, your prospects are reasonable, you've got more than a 51% chance, I always follow that up and say, but that means you have a 49% chance of it going the other way.
Yeah.
And again, the higher the prospects are, so, if you say, well, I think you've got a 75% chance of winning this case, that's a really good prospect, but there's still a 25% chance. And I always sort of try and balance that.
Yeah.
But yeah, so in civil cases, it's on the balance of probability.
Okay. What are the case subjects that tend to be more straightforward than others?
Again, you can't really say. Settlement agreements. So if you've got somebody who is being made redundant and they've got a settlement agreement from their employers that says, these are the terms of the agreement, this is what we'll pay you, etc., they're fairly straightforward, because it's simply a case of going through the document with the individual, making sure that they don't have any issues with their employment that could give rise to a claim through the tribunal, which effectively could potentially give them more compensation than what the settlement agreement offers. So they're fairly straightforward. But again, you could have one neighbour dispute and a very same neighbour dispute. One can be straightforward, one can be really complex.
That's case specific, isn't it?
Yeah. So I think in terms of personal injury cases, you're simple, if I can put it like that, rear end shunts. So, a simple somebody hitting the back of you and a whiplash injury. They're probably less likely to come through our door because of the process is much more simpler for people that act as litigants in person, but they would be a much quicker settlement than serious injuries, for example. Contested probate, again, you could have someone that thinks there is an issue with a will, or they think they should be entitled to something that's not in the will. Sometimes you can get that sorted out really quickly. You do your investigations and actually, the will is valid, it's fine. Or the other beneficiaries in the will say, yeah, we agree, they should have a share of this, which is obviously much quicker than someone that's saying, no, there's a reason the will is written the way it is. There's a reason you were excluded. And, so it's very much case dependent, fact specific.
Okay. I think that's 6.
You've asked 6 questions.
I've asked 6 questions.
Are you ready?
No.
So similar to when you said what is litigation law, and we touched on this earlier. So a family lawyer, I think people think divorce. I'm not married, so therefore a family lawyer is not for me. But what areas of family law do you as a family law solicitor cover?
So most family law solicitors cover all aspects of family law, which is obviously divorce. So when you're getting married, you want the marriage to end, so you get divorced. And then in relation to that, there's usually other areas of law, so the financial aspects of that divorce. So if there's properties, if there's investments, if there's pensions, income, investments of any kind. So we help sort out those finances, how those finances will be shared. And then that agreement's written up into a consent order. So anything to do with the finances of those two people getting divorced.
Yeah.
Then if they've got children, we deal with the children issues, but this could also be for unmarried couples. So any aspect of those children's lives, who are they going to live with, how often are they going to spend time with the other parent, or there could be a dispute. One parent should say, I don't think they should spend any time with the other parent because of X, Y, and Z. So it's sorting out the arrangements for the children. It could be any area of domestic abuse. So, and again, this is for married or unmarried couples. So that falls under the family law bracket of maybe having to go to court to get protective orders for that person that's been the subject of domestic abuse. Again, as I say, it doesn't matter whether they're married or unmarried. The way you deal with it is exactly the same. The court process is exactly the same. The application is the same, so it doesn't matter. So sometimes it's about getting those protective measures in place.
So I would have thought, sorry to interject, I would have thought that domestic abuse, domestic violence would be something that a criminal lawyer would deal with in terms of getting an injunction against that individual. And I think that's probably it's obviously a misconception. So that's something that you
so
deal with.
when the client makes the inquiry first, sometimes I'll say to them, I'll always say to them, have you spoken to the police? Because sometimes it's far quicker to get the police involved because they can take action like that. They don't have to make the applications. They can get someone arrested, go through the criminal process. Sometimes people say to me, I've spoken to the police, and they're not interested. They'll say, it's a dispute just between you two, just
family
crack on sort of thing.
Argument,
so sometimes it's not possible for the police, or they're just not interested, or they don't have the time or resources. Again, it goes back to what the complaint is, how serious the complaint is. If it's if it's an allegation of rape, for example, or assault.
There's probably a crossover then, isn't
Absolutely.
there, in terms of the police involvement and your involvement?
Yeah, so sometimes we'll have to get police disclosure, so we'll have to get reports from the police, we'll have to get the witness statements from the police.
Okay.
It depends. So there's 2 orders you can apply for when it's to do with that protection. Is non-molestation order, which is like an injunction, which people would know. So that's an order to protect the person. The other one is an occupation order.
Right.
That's to exclude somebody from a property that they have a legal right to live in.
Okay.
So if they're an owner of that property, a joint owner of that property, or sole owner of that property, you can apply for an order through the family court to get that person excluded from living in that property. Sometimes with the non-molestation orders, you can get them without giving notice to the other person, depending on the circumstances and whether you fear if you let them know about the application, they will do something to deter you. And sometimes you can get those orders quite quickly and without the other person's knowledge. The occupation order can take a lot longer, because what the court is saying to somebody is, we're stopping you from living in a property you're legally entitled to live in. So the process to get the occupation order is a lot longer. So there is a middle ground. You can have what's called an undertaking. Which is a promise to the court that you won't do certain things. And you can have non-molestation orders while somebody's still living in a property. Because you've got that personal protection. Obviously, again, it depends on the circumstances of what's happening as to whether you then need the occupation order or not. But there's a lot more involved with the occupation order.
That's a subject probably for a whole other episode.
Yeah, absolutely.
But you talked about how you can deal with, obviously, the divorce, the finances, the children. Can you deal with those individually? So if someone's got the divorce but they haven't sorted the finances, or they've got the divorce, the finances, but they haven't sorted out as an issue with the children, can you deal with those individually? It doesn't have to be...
You can to some degree. So quite often people say to me, I got divorced a couple of years ago, but we never sorted the finances out. So then you go on to sort the finances out. Sometimes people at the start of that journey want to sort the divorces and the finances out together. One thing you can't do is in the finances, you need something called the consent order, or just the financial remedy order, depending if it's by consent or not. You can't get that order unless you go through the divorce process. Because the court doesn't have the power to make a financial remedy order without the conditional order in the divorce. And the conditional order used to be called the decree nisi for what people know.
It's not decree nisi and decree absolute now.
So decree nisi is now conditional order, and decree absolute is now final order.
Wow. Okay.
So you can't...
Hopefully I won't need that.
No, hopefully not. So you can have divorce without the finances, but you can't have the finances without the divorce. But saying that, some people don't want to get divorced and not ready to get divorced. So you can have a separation agreement. So the separation agreement will record what the agreement is about the finances, how they're being separated. It's not really legally binding. The reason I'm hesitant to say that is because usually people say, we'll have the separation agreement for a couple of years, then when we're ready to get divorced, we'll go down the route of getting divorced, and then we'll turn the agreement in the separation agreement into a financial order. But the separation agreement can be overturned in different
but that's
circumstances.
Evidence of intent, surely, isn't it? That's
evidence
but I guess things can change in that 2 year period.
Things can change in those couple of years, in respect of their intention, in respect of the circumstances of the individual. So it depends on what you cover in the separation agreement as to whether it's fair when you come to divorce.
And do you deal with pre-marriage?
So also prenuptial agreements, postnuptial agreements. grandparents' rights.
Okay.
I think off the top of my head, that's it.
Okay.
I think.
Okay.
That's a long answer to a first question.
No. I mean, that it's a good illustration. Similar with litigation, it's a good illustration of the broad nature of what you do. It's not. I think people think of a family as, you know, husband, wife, 2 kids sort of thing, and it goes beyond that, doesn't it?
Absolutely.
And it goes beyond divorce.
Yeah. What I would say is some family solicitors don't like dealing with all areas of law. So some will just specialise on finances, some specialise on children.
Again, similar
so
with
depends.
litigation, some specialise in you know, disputed probate, etc. So you said that a lot of times people will call you and say, I'm getting divorced, I'm separating, can I keep the house? How do you answer that question? Surely that's case dependent.
Yeah, and a really, really common question is, what am I entitled to? Very, very. It's a very common question. You can't answer that question at the first conversation. You've got to do a bit of a fact find. You've got to get a lot more information. You've got to get information from the other party. So people will often say to me, well, I know because I've dealt with the finances. But I say to them, I can give you advice based on what you're telling me.
Yeah.
But I need the other person to tell me and to give me that information before I can give you full advice. So I can give you, so it wouldn't be a question I can answer in a 15-minute phone call. What I usually say is, you know, let's get together, let's have a consultation, let's go through the information that you've got, and I can give you an idea of what the result could be. But again, it's dependent on me getting more information.
Okay, and that, another question that's it's going to be 7. Another question that just popped into my head. That initial consultation, do you charge a fixed fee for that?
Yes.
Okay.
So I offer a reduced fixed fee. So obviously our charges are based on hourly rate. So I would offer a reduced fixed fee and have that consultation, give them that initial advice.
Okay.
Yes.
Okay. How can I protect my pension in a divorce?
I think it's a similar question to the overlap of the question you just asked me. So it depends. And again, it's very case specific. So for example, short marriages, the court like to take the approach of you leave the marriage with what you brought into the marriage. But again, that then depends on, are there children involved?
Yeah.
It depends on the other assets. So there's lots of things you can do with pensions. You can have a pension sharing order. So you say, the person who wants some of your pension, you give them a percentage of your pension, invest it in their own pension, and you can maybe keep more of your pension. Yeah. But you then offset that against other assets.
And would that be an immediate transfer?
No.
So that's when the pension is...
Oh, yes. So at the time, so what happens is when you've got the agreement and the agreement's written out into the financial order, the court approved that. It then goes to the pension company, and then they have 4 months then to implement the pension sharing order. And what they're doing is, say it's 25% of the pension, it's 25% of that the value of the pension at that point in time. So what people can do is, if they know they're going to go down the divorce route, to try and to preserve some of the pension, they can say, well, I'll stop investing in my pension at this moment in time, because obviously any pension that I invest now is post-separation. And then when it goes to the pension companies, say they then look at the value of the pension as it is now and then take a percentage of the pension and transfer it to the other spouse.
So it's immediately transferred. So when that individual who has had to surrender, if you like, part of that pension, when they come to claim that pension, they've then not got to give that percentage.
Not the future pension.
Right.
No, it's whatever the value is now.
Because again, my sort of thoughts are, well, the idea of the financial order, etc., is a clean break.
Yeah, clean break.
So, you know, to have to get in contact with that individual in 10 years' time when I retire is not practical.
No.
Okay.
No. So it's the here and now. And I say you can do offsetting, and it always depends on... So I will say to people, you know, what is it that you're looking for? Are you looking to get more capital now? Or are you looking to get more income now? So that comes down to their ages. So if they're years and years off pension, off retirement age, then they may not be too interested in their pension. They may be happy to give some of their pension. If they need more capital so they can get their housing needs secured, then again, they may not be interested in the pension. But if they're older and their housing can get sorted, then they're more inclined to say, well, I want some of that person's pension then. So again, it's case specific.
Yeah. Okay. So as a client, how do you communicate with them? How do you update them, and how often?
So it's emails, telephone calls, video calls, depending on what the preferences of the client, depending on where they're based.
Yeah.
But it's a mixture. If it's a quick thing, I'll just pop an email over to them. Sometimes I'll do a letter, send it in an email. Mostly it's email.
Yeah.
There is the odd person that doesn't communicate by email, so they'll have to do letter or telephone call, depending on their circumstances. I don't like to send emails for the sake of it, so I won't say, oh, there's nothing happening.
Yeah.
But then I get the flip side of that is if people don't hear from you,
Yes.
they're wondering.
Yeah.
So it's specific to that individual person. You get to know their
what their
personalities,
needs,
their
absolutely.
characters as the case progresses.
Yeah. $1 million question,
Gosh.
literally. How expensive is using a family lawyer?
I think the way to look at it is not what it's going to cost you, but what will it cost you if you don't have a family law solicitor.
Yeah.
So yes, obviously you do have to pay for our services, but you're looking at what it is that you're trying to achieve and what could you get, what can you get by instructing a solicitor?
Yeah.
Because obviously we have the knowledge, we have the expertise, we know how the court works, we know the rules, the procedures, the process, we know what's involved.
Yeah.
A lot of family law, when we're looking at financially, is about negotiating.
Yeah.
As a layperson, you won't know that. It's the same like if you've got something wrong with your car. If you
Yeah,
try and fix it yourself,
yeah.
you can end up spending more
Making
money.
worse.
Yeah. So,
And again, I guess it's very case specific, isn't it? If you've got let's call it a simple divorce with no finances, etc., that's going to cost a lot less than somebody who's got lots of assets. And
we can offer fixed fees as well for divorce. We can offer fixed fees for straightforward consent orders. So fixed fees, obviously, you know what you're paying at the beginning of the case. You pay it up front. You've got no other cost to pay. So it depends on what the issue is.
How often, because we do fixed fees for certain things, but I always put a caveat on there to say this fixed fee covers A, B, C and D.
Yes.
If any extra work is required over and above that, then
reverts to the hourly rate. Yeah. So you've got to have that caveat in.
Yeah.
Because sometimes, even in a straightforward divorce, sometimes the other person decides, well, actually, I'm not going to engage. And then you've got to then get someone to personally serve the divorce application on the person.
Yeah.
That's more cost. That takes it outside of the fixed fee. So you do have to have that caveat. Yes.
So I think you've actually answered this one, number 6/7. I've been a victim of domestic abuse. How do I get my partner to leave the property?
Yes, that's the occupation order. Yeah, if the police don't get involved, occupation order.
Yeah, okay. Well, that's
my 6.
That's your 6.
I'm going to have a drink of water.
My dear. Shall we have a quick break?
Yes, let's have a quick break.
Come back for
While we do,
6.
some exciting news. We're now sponsored.
We forgot to say that we've got a sponsor for our podcast.
We have a sponsor. Are you excited?
Go on.
Shall we tell everyone? Our sponsor for today's episode is the oak tree outside Everard's. They're sponsoring us.
Round of applause. Let's take a quick break and we'll be right back.
Right back.
Okay, welcome back to the second part of our fact-finding episode, if we can call it that.
We can call it
Geraldine.
that.
So we're finding out. I've learned quite a bit actually about what you do as a family lawyer, and I've known you for years.
I know. Vice versa.
Yeah. Well, I think,
yeah.
And that shows probably how little people understand what
we do.
Certain types of lawyers do.
Okay.
So, yeah, you're going to go with the next 6 questions.
Yes, I am.
Me then, aren't
so,
you?
what is the first thing I should do if I receive a notice of a claim?
Wow. So if you receive what's called a claim form,
okay,
which is a formal document issued through the court, the first thing you need to do is check the date when you are required to respond by, and that will be stated on the claim form and on the notice of issue. And you have to find an acknowledgement of service to say that you've received that claim form. Normally that's within 14 days of service, so you have to file that acknowledgement of service with the court and with your opponent. That gives you an extra 14 days then to file your defence.
Not that long, is it?
It's not that long. You can request an extension of up to another 28 days. And generally speaking, that's normally agreed. If you think it's something that you can deal with yourself or that, you're going to admit, then that's absolutely fine. You will have what's called a response pack when you're served with the claim form, which is sort of a tick box in terms of I admit part, I admit whole, I'm going to pay this, pay that, whatever. But if you're in any doubt, then Citizens Advice Bureau, legal clinic, or contact direct to a lawyer. If you don't file your acknowledgement or your defence within the time limit, then what happens is the claimant can enter a request for judgment, which means effectively they don't have to prove their case because you failed to respond to it. And then it's simply a matter of the court deciding in default of agreement what you have to pay by way of damages or compensation, or if it's a debt claim, for example.
Surely you don't have to get all of your evidence in within the 28 days effectively then?
Well, normally what happens is that there's a pre-action protocol, okay? So it's very unlikely that you will receive a claim form out of the blue.
Oh, okay.
You will have had correspondence from the claimant, either directly or through their insurers or their solicitors prior to that issue of proceedings. So generally speaking, you will know what the claim is about. You probably will already have exchanged that evidence in terms of, no, I don't agree with what you're saying, and this is why. And it's like we were talking earlier about, do all cases go to a trial? That there is the protocol to follow before you get to the point of, right, we've tried to deal with this. The only thing we can do now is to issue court proceedings and ask the court to get involved. So it's unlikely you'll get something out of the blue.
Okay.
Sometimes, in fact, I've got a case on at the moment where the defendant had moved house and so didn't get the claim form.
Oh, okay.
And only became aware of it at a much later date when his insurers wrote to him and said, look, we've had this claim and we're not going to cover you, basically. And so, there are things that you can do in terms of making an application to set aside the judgment, etc. But that's sort of another topic, and that can be risky and costly. So I think if in any doubt, contact a legal advisor immediately.
Okay.
If you're insured, if it's a road traffic accident, for example, or a claim against you as an occupier of a property and you've got insurance, contact your insurers immediately. Don't sit on it. Don't ignore it. Don't think it's going to go away, because it won't.
Fair enough. What can I do to keep my costs down?
Be sensible.
Yeah.
I've got clients who are paying on a private basis and they will email me with one question, follow that up with another email about another question, follow it up with an email about another question. But there's probably a day in between. So I'll deal with that first email, answer to it. Then I have to deal with the next and have to deal with the next. So each time I have to review your file, I'm having to charge you. So think about what you want to ask and put it all in one email. We can deal with it all in one go. Don't be the client that rings up every day to see if something's happening. Believe me when I say to you, when I get the information, I will give you that information. And I think be open-minded to compromise, particularly with litigation, because it's highly unlikely you are going to get everything you are asking for. And so pick your battles, think about what's important to you, what you can let go. It's not about giving in. It's not about letting them have what they want. It's about reaching a quick compromise, a quick settlement as soon as possible and as cheaply as possible for you. Be reasonable. Again, what we said earlier, you've instructed me for a reason. I've got the expertise, I've got the knowledge, I've got the experience. Believe what I say, trust in me. And, for me, it's great. If you want to email me 5 times a week and that means I've got to respond 5 times a week, that's fine, because obviously you're paying me for that. But that's not what I'm in it for.
Yeah.
I'm in it to help you reach an agreement.
Yeah.
Okay.
That's helpful. What are the biggest differences between being the defendant and being the claimant?
Good question.
Thank you.
So, obviously, a claimant is the person that brings the claim. The defendant is the person that defends the claim. As the claimant, you have to effectively front load your claim. So if you are dealing with a dispute with a builder, so they've done some work, the work's defective, you want your money back or you want them to pay for the work to be rectified. So you'd need to get an expert's opinion on that. So you need to get an expert report saying, this is what the work that's being done, this is what needs to be done, and this is the cost of what needs to be done. And then when you've got that report, you can then prepare what's called your letter of claim or your letter before action, which says to the defendant, this was what our agreement was, these are the issues, here's the evidence, this is what we want you to do. As the defendant, obviously you respond to that. Quite a lot of defendants will say, don't agree with you, go away, do what you need to do. Others will then instruct solicitors or will respond and say, yes, I agree with that bit, no, I don't agree with that, this is what we can do, etc. So the claimant, effectively, the burden is on them to prove their claim. You can't simply say, you've done this, I want this. You need to prove that. So for a claimant, the costs tend to be much higher because you do a lot of the preparation prior to actually being in a position to be able to serve that initial notice. That's more so in clinical negligence claims because you have to get quite a lot of expert evidence before you can say, one, whether you've got a claim or not, and then two, what the formula is in terms of the basis of that claim. So, yeah, does that answer your question?
It does. Yeah, it does. Very much so.
Good.
What factors could make a case more expensive, I suppose?
So, again, unreasonable demands from the client, the level of expert evidence required, so the type of expert. So, if you've got a personal injury claim, a report from a GP is going to be much cheaper than a report from a spinal surgeon, for example. So if you've got someone who's got minor injuries and it's a GP report, that's going to cost a lot less than someone like the case we've talked about where we had a spinal surgeon, ENT, psychiatrist, all these sorts of things. Obviously, if you've got a case that is strongly defended, then that's going to cost you more than someone that puts their hands up and say, yeah, you know, you've got me bang to rights, I agree, what you're saying is true, let's see if we can agree a settlement. I think ignoring legal advice will increase your costs because, and at the end of the day, it's your case. You know, if I say to you, what you're asking me to do is likely to result in a non-favourable outcome for you, but you say, I don't care, I want to go ahead and do it, that's going to cost you more money. You know, so again, come to the table with an open mind, not an open wallet.
I suppose with the expert reports, do they get paid as and when from the insurance company?
So normally you as the claimant need to pay that for that report. Okay.
Oh, wow.
If you are successful, then those costs will be recoverable from the other party.
So your insurance company doesn't pay for those expert reports?
Sometimes you don't have insurance. You know,
Wow.
if it's a neighbour dispute, you're not necessarily going to have insurance to cover that, so you have to pay privately.
What about in the medical negligence cases?
Yeah, so that's normally on a no-win, no-fee and would have insurance to cover those liabilities.
Yeah.
So you are protected because those reports can be.
That's what I was thinking.
You know, I have had expert reports that are 30,000 plus. You know, but in your general litigation on a private fee-paying basis, you as the claimant would need to pay for that report. And as a defendant, if you don't agree with the claimant's report, you know, you get your own report. So there are costs involved on both sides. Yeah, and I think attitude to litigation will cost.
Yeah.
You know, one way or the other, I think.
Okay. How often is there an opportunity to settle early?
There's always an opportunity. Day one. And again, it's about being prepared to compromise and not being bullish in your approach, and and understanding that you may have to give a little bit of your fight up, if you like. And that goes both ways. But yeah, there's always an opportunity to settle. Settlement in a litigation case as opposed to a personal injury or clinical negligence case, I think, are looked at or should be looked at very differently. Because settling a personal injury or clinical negligence claim too early can result in an undersettlement. So if you haven't got all of your expert evidence, you haven't got a clear picture as to what's going to happen in the future or what could happen in the future, and therefore you can't adequately compensate your client. Whereas in general litigation, it's quite clear in terms of this is my loss, this is how much it's going to cost. So there's normally not too much ambiguity in terms of whether, you know, that's the right settlement or not. But yeah, always be open to consider offers that come in or offers that we want to make. And the idea is that you look at that offer in terms of it might be less than what you potentially could get on day 20, for example. But because that offer is made on day 2, you're saving all of those costs to get to that point. So is it worth spending another £5,000 to get another £2,000? You know, so again, keeping that open mind at all times.
Okay. And similar question to me, how will you communicate with me and how often?
Again, one of the questions that I ask the client at the outset, whether that is somebody that's on a no-win, no-fee agreement or private paying, is how often and how do you want me to contact you? Do you want me to tell you that nothing's happening, this is what I'm waiting for, this is what I'm going to do? Or do you want me to just tell you what's happening at the point something is happening? A lot of my clients prefer things by email. Some of the clients are not tech savvy, so they would sooner have a telephone call. I've got clients who are hard of hearing, so they prefer correspondence and they don't do email, so it's letters in the post. That's probably the least favourable way, to be fair.
Takes a long time, doesn't it, these days?
But on average, I find that I'm updating my clients. Something is happening on their case at least once a month.
Okay.
And, you know, if somebody says, well, I want you to tell me that, you know, a bit like you know, you don't want them to think you've forgotten about them. So at the outset, I'll say, you know, if you want me to update you, even if nothing's happening, then I can do that. But, you know, that's going to incur a fee.
Yeah, that's it.
And most say, just tell me when something's happening.
Yeah.
You know, and there's always that opportunity. If you haven't heard from me for a while, or you think, you know, we need to put more pressure on, or you want to something, then you can always pick up the phone or send an email. And then obviously the charges apply accordingly. Yeah.
That's it. Thank you very much. That's very, very helpful.
Good. I'm glad.
Very interesting.
Now then. We've talked before about pensions. How can you protect your pension? So is it always the case that you are entitled to your partner's pension?
If you're married, yes.
Okay.
If you're not married, absolutely no entitlement whatsoever. None whatsoever.
Okay.
As a non-married person, the only entitlement you have is any jointly owned properties.
Okay.
That's it.
Okay.
As a married couple, you can always claim on the pension, but the claim depends on how long you've been married.
Okay.
The court's approach to pensions has changed over the last few years. So a few years ago, it was always what the pension, however much was accrued in the pension pre-marriage, was ring-fenced.
Okay.
But now it's just everything. Even if you've been married for 5 years, but you've had your pension for 10, that whole 10-year period is now up for grabs. So there's always a claim on pensions when you're married.
And is your advice, this is an additional question, is it your advice always to look at the pension?
100%.
And is it easier, better, or do you advise to offset that pension? So if for example, 25% of that pension is worth 50 grand, would you say, well, we'll leave your pension alone, but we want 50 grand here, or whatever?
Well, it depends. Again, it depends to the the specific circumstance of the case, their age. So younger people say they're not really interested in pensions, because if you were to do a pension sharing order and get a percentage of the other person's pension, you can't touch that anyway until the age of 55. So you've got to wait.
Yeah.
If you're older, then obviously you can take advantage of the pension.
Yeah.
And again, it comes back to what's important to you. Is it capital or is it pension?
Okay.
It depends on the value of the pension. It depends on the type of the pension. So every pension can then have it, so you can get defined benefit pensions. You can get final salary pensions.
Yeah.
There's different types of pensions, and every pension
and that will have an impact.
Yeah, has a different benefit. So sometimes, depending on the value of the pension, you might need to go and get a pension expert report. An actuary, they will look at the pensions of both parties, look at the ages, etc., and then say this is how that pension should be shared, and then you can look to offset that. And again, it depends on what's important.
So I could imagine it can be quite complex working out finances and pensions. So you'd probably do need the outside advice.
But again, it depends. So an actuary, obviously, they can charge you anywhere in the region of, say, £5,000 if you split between you. If you've got a pension with £10,000, then you wouldn't do it.
No.
So it depends on the value of the pension, and the type of pension, and what it is that you're looking to achieve.
Yeah. Okay. Do we still need a court order if finances are agreed?
Absolutely.
Okay. And I know why that is. But tell our listeners why that is. So
a lot of people get divorced and they just say, oh, we've sorted the finances out, we're happy. Or even if you go through the process where you reach an agreement and in their mind, that's it done.
Yeah.
But if you don't have the consent order or the financial remedy order, so that is the order that makes the agreement legally binding and hopefully gives you that clean break. Without that, your finances aren't severed between you. You're still financially linked to one another.
Okay.
Even if you reach an agreement and then say 10 years down and you don't have the order, 10 years later you've still got a claim on that person's finances if you don't have that clean break order.
And is that the case if you both sign a letter to say we agreed to this?
Yes, absolutely.
It has to be a sealed court order.
Absolutely. So I think I gave an example
certainty, isn't it?
of a case where they got divorced, they'd sorted out the finances, one party had even signed a consent order, but they hadn't sent it to the court. The wife then decided she wanted another go. And they were still open. Those claims were still open. So you've got to have a signed consent order and it's got to be approved by the court. That's the only way to make that agreement legally binding.
Okay. What kind of children orders can the court make?
So they can make a variety of orders. So the terminology has changed. It used to be things like residence and contact.
Yeah.
So you now have an umbrella term of child arrangements orders.
Okay.
So that is a live with order, which is a residence order, which says who the children will live with.
Yeah.
You can have used to be called a contact order. It's now time spent with. So that's how often does this child spend time with the other parents. You can have specific issue orders. So that is to do with a specific issue of a child's life. So like a change of surname, moving schools, moving to a different country, education decisions, specific issue to do with that child's life. You can have prohibited steps orders. So a prohibited steps order prevents a parent from doing something in relation to that child. They're the main orders in relation to children.
And would they be individual orders if all of those applied, or would it be on one order?
One order.
Okay.
Yeah.
And it would I guess be headed in terms of
child arrangements orders, spend time with, prohibited steps specific. There are other niche things like special guardianship orders and things, but that's primarily the main orders.
Okay. The next question, we did speak with somebody who specialises in this, and I think we did touch upon this, and it was quite a enlightening, I think, episode. But what is domestic abuse? What can it consist of?
Wow. Well, it can I can't get my words out today. My mouth is dry. It can consist of lots of things. So domestic abuse is an umbrella term. So it's abuse or violence of any nature. It can be emotional, it can be physical, it can be psychological, financial. It's coercive controlling behaviour. And it has to be for the family court, it has to be between two people that are linked in an intimate way.
Yeah.
So it doesn't have to be, you don't have to be married, for example, but you have to have that interlinked relationship. So it's any aspect of your life that is harmed in some way by the acts of the other person.
I think that the kind of common misconception is that it has to be, you have to have a bruise, you have to be hit, you know, whatever.
Yeah.
But I think more so, and rightly so, recently and of late, it's been more about the coercive control, the emotional abuse, and the impact that has on people.
Yeah, because I'll sometimes get clients say to me, you know, oh, I don't know whether I should be doing this because there's no evidence as such. There's no physical evidence. And I often say to them, you know, don't minimise the emotional harm, the emotional abuse that you've been subjected
100%.
to, because that can stay with you a lot longer than, like you say, a bruise or a smack or whatever.
And it, you know, it affects your future relationships.
It affects everything. It affects you, if you've got children, it affects you as a parent.
Yeah.
It just affects every aspect of your life.
Yeah.
The courts are getting better at recognising the coercive controlling behaviour now, because obviously it's always been around, but the family courts haven't been great at dealing with it, so it is getting better.
Okay.
So yeah, it's any aspect that harms you in any way. It doesn't have to just be physical. It can be anything.
Yeah. Final question, and thankfully this isn't a problem for me, but I know that I've had people ask me, what rights do grandparents have? So if you've got a man and a woman, or a man and whatever, have got a child, they separate and one refuses the other's set of grandparents contact with that child, what rights as a grandparent?
Yeah, and it does happen an awful lot, sadly. So as with parents, they've got parental responsibility, which means they can automatically make an application to the court.
Okay.
As a grandparent, you don't have parental responsibility. So your first application to the court is asking for permission to be able to make an application to spend time with the child. And in that part of the application, asking for permission, the courts will look at things such as your reasons, your motivation, your connection, your bond to that child. Okay. And if you can satisfy that, the court will then allow you to progress your application in exactly the same way as a parent. So then it goes to the next step. And
so you have to make an application for permission to make an application.
It's one application, but the first part of the application is applying for permission to make the application.
Yeah.
In every case I've dealt with, it's been granted, always been granted.
Yeah.
Because obviously I wouldn't imagine that you would make an application if you don't have a connection to that grandchild anyway. Yeah. So the court would look at that aspect first, and it's dealt with in the same hearing, the same initial hearing. So the courts will look at that part of the application, and then if that's granted, then they go on to then look at the real aspects of the application. And when they're making an order for a grandparent to spend time with a grandchild, it's obviously not as regular as it would be for a parent. Yeah. For loads of reasons, practical reasons, logical reasons. Usually what the courts will say, and again depending on location and the child's age and what the child is doing, and obviously usually if you've got a grandparent make an application, it means the parents are separating. So then the court have to think of, okay, we're allocating this amount of time to the non-resident parent. We've then got to think of what time is left for the grandparent to spend time with the grandchild. So it could be one day a month, it could be one day every 3 months. For example. But so they don't have automatic rights.
Or the same rights, I guess. No. Unless in exceptional circumstances.
Yes.
Wow, well, I've learnt a lot.
Good, I'm glad you have. Well. I have, absolutely.
If there's, to our listeners out there, if there's any questions that we've not asked each other, or there's a specific question that you want to ask, then please get in touch with us. We do have a new email address, and I'm hoping I'm getting this right. It's lawfullyyourspod@gmail.com.
Yes.
So you can email Geraldine or I at that email address with any questions that you might have, and we can either answer you directly if it's sort of case specific, or we can, with your permission, we can talk about it on air, obviously anonymously. So Geraldine, thought for the day. Here we go then.
So, we don't perceive the world as it is, but as it is useful for us to perceive it. Our senses and brains evolved not to be objective scientific instruments, but rather efficient survival tools. The colours, sounds and smells we experience are a customised user interface that guide our actions, not a perfect mirror of reality's true complexity.
Wow.
That was a mouthful, wasn't it?
Yes, it was.
Yes. Do you understand
the actress
it?
to the bishop.
Took me a while to figure out what I was going to
very
say and how to say it.
profound. Well, before we conclude episode 6, season 2, all is left to say really is that we are on Instagram, Lawfully Yours Pod, and we are now on TikTok.
Woo-hoo! Exciting.
Apparently. Thankfully, we've got a man that knows what to do because we've got no idea. That's awfully yours. That's
Awfully Yours.
That's also Lawfully Yours Pod. So follow us, like and share. We're on all your favourite platforms and we're also on YouTube.
We are. Exciting.
We are indeed.
We should do an episode in front of the oak tree outside Everard's.
Well, I think your mission after this episode is to go and take a photograph.
Yes.
And we can have it on our socials as sponsored by.
I like that. Yeah, we'll do that.
And the aim is to find a new sponsor for episode 7.
This sponsor is a bit quiet, doesn't really say much.
No.
Just gives us the air we breathe.
Very important.
Very important.
Very important. So thank you all for listening. Thank you, Geraldine, for joining me today.
Thank you, Vicky.
It's been very enlightening. I've enjoyed it. And whilst this episode will be out after Christmas, that is us.
That is us.
Thank you and good night.
Goodbye.